I'm rising today because of what I believe is the urgency of the moment, or really the test of the times. We know that we are a constitution that was designed with three co-equal branches of government. And we know the importance of each of those branches and the roles that they have spelled out in the Constitution. Now, a functioning Supreme Court, one of the co-equal branches, is of the utmost importance to the proper functioning of our democracy. Judges decide cases that decide and shape the daily lives of Americans. Even one justice can deeply affect the rights and liberties of the American people for generations to come. Yesterday, the United States President nominated Chief Judge Merrick Garland to the Supreme Court of the United States. Now, a clear, plain reading of the text of the Constitution says in Article 2, Section 2, that explicitly that it is the duty of the Senate to provide advice and consent to the President on key nominations, particularly justices to the Supreme Court. Now, I'm one of those folks with my 99 colleagues that took an oath of office. We swore to support and defend the Constitution of the United States and to faithfully discharge the duties of the offices we hold. There was no addendum to the oath that excused us from our responsibilities during a presidential election year. I was elected to a full 6-year term, and my work in the Senate should not be interrupted. My duties and obligations of any of the 100 of us should not be interrupted by a presidential year, especially when those duties are explicitly laid out in the Constitution and involve the co-equal branches of government like the Supreme Court. Now, I've only served in the Senate since October of 2013. This is my first Supreme Court nominee to consider, and I'm looking forward to reviewing thoroughly Chief Judge Garland's record, to meet with him face to face, and hopefully, I believe, rightfully, vote up or down on his confirmation. This is what all of us swore an oath and signed up to do when there is a vacancy on the Supreme Court. That's the duty that the American people expect us, to abide by the Constitution and provide that advice and consent regarding a presidential nomination of this import to the United States Supreme Court, that co-equal branch. Now, we may not ultimately agree on Chief Judge Garland's nomination. The Senate can vote no. Senators have that independent choice. It happens almost every day here where we disagree on issues. There's no guarantee in the Constitution that the person that the president nominates should get confirmed. But we should agree at least that this process spelled out, the process that we were elected to do, should move forward. No issue of a Supreme Court justice's nomination process, none of this is bigger than any one party. Now, as I understand it, we already are seeing that Chief Judge Garland is highly respected, experienced, and a deliberate jurist who the Senate overwhelmingly confirmed in 1997 to the U.S. Court of Appeals for the District of Columbia, known as the second highest court in the land. His nomination to be an associate justice on the Supreme Court of the United States is certainly deserving of our consideration. Chief Judge Garland, in fact, has more federal judiciary experience than any other Supreme Court nominee in history. He currently serves as Chief Judge on the United States Court of Appeals for the District of Columbia, where he's worked since 1997, serving under both Democratic and Republican presidents at the Department of Justice. He first worked as Deputy Assistant Attorney General for the Criminal Division and later as the Principal Associate Deputy Attorney General. In those posts, he served major cases at the Department of Justice, like the prosecution of the Oklahoma City bombing, which ultimately brought Timothy McVeigh to justice. To call his qualifications impressive is an understatement. Chief Judge Garland has dedicated his life to public service, and his lengthy career reflects his commitment to the high ideal etched on the Supreme Court itself: equal justice under the law. He has said that the role of the court is to apply the law to the facts of the case before it, not to legislate, not to arrogate itself the executive power, not to hand down advisory opinions on the issues of the day. No wonder he is known in legal circles and around Capitol Hill for his careful opinions and lack of overt ideological bias. Chief Judge Garland is so well admired, so highly regarded, and so accomplished that his appeal transcends the typical partisan divisions that really are all too often seen in Washington. There is no possible explanation based on this nominee's reputation, their experience, their dedication, their service, and their work. There is no possible justification to ignore or blockade or stonewall Chief Justice Garland's nomination in hearings in a process. There's no reason for that. And there's certainly no historical or constitutional precedent for what is being suggested. There's no precedent at all for this kind of blockade. Since committee hearings began in 1916, every pending Supreme Court nominee has received a hearing, except for 9 nominees who were confirmed within 11 days. So what is being suggested to not even meet with the justice, to not even give them a hearing, is unprecedented in the history of our country since we were holding judicial hearings. History shows us that the Senate has previously confirmed Supreme Court nominees during a time of a political climate similar to ours. The excuse that this is a political election season or a divided, contentious political climate simply falls flat in the face of our history. In a presidential election year, 17 separate times during the presidencies of liberals and conservatives, Republicans and Democrats alike, we have held Supreme Court nomination hearings. In fact, the presidents Roosevelt and more recently Ronald Reagan saw their Supreme Court nominees confirmed in a presidential election year. Since 1975, the time that has taken, thinking that maybe perhaps we don't have time to consider a Supreme Court nominee, since 1975, it's taken on average a little over 2 months for the full Senate to consider a nomination before voting. It is only March right now. So there is plenty of time to consider and confirm a nominee. There is no reason why Chief Judge Garland can't be confirmed by even the end of May, given the average time, which is more than ample time for the next judge to be on the court before the next Supreme Court term begins in October. When the Supreme Court, that co-equal branch of government, has a body of work to do, to not do this process is to deny that co-equal branch of government its full functioning complement of members. This is a time that is a test for this body. It is a time that's going to test the dignified confirmation of the process for the next Supreme Court justice, and it provides us as an opportunity amidst all of the partisanship, amidst all of the decays that are going on, the rhetoric. It's a time for this body designed to rise above that, to show that we will operate with a level of dignity and honor and commitment, indeed a fealty to the Constitution, that shows that we are not susceptible to the winds of the time. Now look, I believe Chief Judge Merrick Garland deserves this, but in honesty, that's up for each and every senator to decide whether whether he should be a Supreme Court justice. But for me, it's not about the individual. I've heard some of my colleagues saying simply, let the people decide. That sentiment seems to resonate at first, letting the people decide. We are in a mighty democracy. But the reality is, the people have already decided. They decided when they voted for 100 members that we should do our duty. They decided when they voted for Barack Obama that he shouldn't be a 1-year president or a 2-year president, that he should serve a full 4-year term and conduct his duties, his sworn duties. Neither any individual in this body nor the president should shirk from fulfilling their constitutional obligations. The people decided in the democracy when they elected us. It is time for us to complete our jobs. It's time for us to do our jobs. Now, we have deep histories of fights, not only in this body, but in our larger democracy. There's been divisions in this country, factions, literally written about in the Federalist Papers was an acknowledgement that there would be divisions and fights, but we designed a Constitution to cull from our divisions and our differences a nation that is mighty and strong, and I am so proud of that. Because as much as our differences matter, we've always seemed to understand that our country matters more. The people who founded our nation understood those two dueling understandings, that differences, diversity of thought are going to make our country great, but they also understood for our nation to be successful, to endure, there must be times where we have a loyalty to ideals and principles enshrined in the Constitution itself, reflected in our democracy, that there are times where we must come together. In fact, it harkens to the very hallmark ideal of our country, e pluribus unum, from the many one. It is written into the cultures of all of our country. They're like the old African saying that if you want to go fast, go alone, but if you want to go far, go together. It's why in the very Declaration of Independence, where we are affirming the idea of individuals being endowed with their creator, with inalienable rights, when we are talking about individuals, written into the Declaration of Independence was a nod toward what it would really take for our country to remain strong. Those individuals ended that document pledging to each other their lives, their fortunes, and their sacred honor. There is no greater honor of my life than to have stood in this well before the vice president and swore my oath that I would uphold the Constitution. In fact, that I would at times, when I have to, sacrifice self for country. These are the ideals. This is the honor that I believe has helped our great country to persevere. And now we have this test, this moment where two conflicting ideals have been put forth. Whether a president and a Senate should fulfill their obligations all the way to the end of their sworn terms, or should we begin to truncate the powers of a presidency and the powers of individual senators to suspend their constitutional obligations because it is an election year? To me, that undermines the purpose, the thought, the spirit of our constitutional institutions. So now here's the test. I worry that we will fail this test and we will descend deeper into the kind of divisiveness that undermines our Constitution. This is a time, I believe, that calls for an honorable stance. That, hey, there is a Supreme Court justice of extreme competence. I'm not going to blockade. I'm not going to even meet the person. Hey, we're going to hold hearings where we may decide that this person is not good enough, but each individual senator will honor that process and that precedent that's been continuous for years and years and years. And then we will have an up or down vote. The purpose spelled out in the Constitution, Article 2, Section 2, written into that sacred text, is that right here on this floor, we should let the president, through our vetting, that we should put forth our ideas in an up or down vote about the confirmation of a nominee. Again, we're here because greater Americans pledged to each other, as different as they were. They came together and wrote a Constitution. They wrote a Declaration of Independence. We're here because people greater than us pledged to each other their lives, their fortunes, and their sacred honor. In this process, let us hearken to that honor. Let us put forth our sacred honor now, not allow this country to lurch even deeper into divisiveness. Let us unify and show that, yes, there are differences. Yes, there are divisions. Yes, there is partisanship. But in the end, we will unite around those bonds that hold this nation together and that will ensure that our democracy functions for years and decades and generations to come. Mr. President, I yield the floor.